Hello, class. Good to see you again. Hope this message finds you happy, healthy, safe, and sound. Today, we're going to talk about civil liberties, which are your freedoms from the government. So, civil liberties are just that. They're freedoms. If you think about the word liberty, in today's language, we don't use it as much, but the idea is freedom, right? So, civil liberty is a freedom from government interference. That's the simple definition. Civil liberties are freedoms from government interference. So we're going to go through a list of those. You could start easily with the First Amendment, right? The First Amendment is the definition, has four parts to it, remember? You have freedom of religion, freedom of speech, freedom of press, and freedom of the assembly, as you see all over the country, right? Peaceful protest. So you have those four civil liberties. And what we're saying in the discourse of civil liberties is that the government cannot take away those rights. They can't take away those freedoms from you, as long as you're doing them within the law, right? So, for example, the government cannot make you go to church. The government can't prevent you from going to church. The government can't make you go to mosque. The government can't prevent you from going to mosque. They can't make you go to temple or whatever the case is. They can't make you be atheist. They can't prevent you from being atheist. There's civil liberty is the idea that there is an absence of government, and where there's absence of government, there's personal freedom. So you could write that down as a nice little line, is that as freedom expands, as liberty expands, government contracts. So if something's getting bigger, the other's getting smaller as a result. So civil liberties are the space where your freedoms lie and the government is not allowed in that space, like your freedom of speech, right? So remember what we said. If the Westboro Baptist has the right, according to the Constitution as interpreted by the Supreme Court, to say the most hateful and vile stuff, then you know that the United States has a very robust First Amendment freedom of speech in this country. Basically, you can say just about anything about your leaders as long as it doesn't threaten them physically. As long as you're not threatening them, there. I've seen. It's amazing to me still to this day. It is one of the amazing things about the United States is you can see President Trump's Twitter feed or former President Obama's Twitter feed, and they'll say something, and right underneath it, someone I saw on Trump's, he posted something, and I don't even know who the person was. I don't know that they're even famous. They just like went off on him like you're the worst president ever. And it's just amazing to me that we have that much freedom where you can tell the president off to his face over Twitter, if you will. So what does that all mean for civil liberties? Is that this is the core point I'm trying to drive home in terms of freedom of speech specifically. It also applies to freedom of assembly and freedom of the press. The government cannot stop you. They cannot infringe on your civil liberties as long as you're nonviolent, right? So that's huge because if they do infringe, then they're the ones breaking the Constitution, not you. So another example, so that's the First Amendment. We've already covered that. You all know that by heart by now, hopefully, right? Probably one of the most controversial civil liberties today would be the Second Amendment, which is the right to bear arms. And the government's saying in the Constitution, right, they won't infringe. That's the word of the day. Infringe means to get up in your space. That's not the formal definition. Infringe means to take over a space that isn't yours in this context. You're not you're not allowing the person to have their Second Amendment rights if you're infringing on them. Does that make sense? So but there's a debate. Does the government infringe on your right to have a machine gun? Yes, you cannot have a machine gun. No one can buy a machine gun. So does that mean that you don't have civil liberties in regard to the Second Amendment anymore? No. It means that our country has come to a consensus that this is the boundary. Yes, I have a crayon. This is the boundary of how far this amendment goes, and there'll be debate until forever, I think, over how much freedom do you get in the Second Amendment in terms of what kind of gun, how many rounds can it have, all of those questions. They're fascinating questions, and if I were the Supreme Court, and I would guess this is the case, they're going to stay out of almost all of it. Unless there's a question about restriction of guns that they feel is, four of them, remember, feel that it is necessary to take on. I would guess that this is just going to be a debate where politicians will hopefully, listen to the will of the people, which hopefully is wise, and come to some type of agreement. But that just shows you the complexity of civil liberties. It's not just as simple as us having them. It's the question of how far do they go? How much can you push freedom of speech? Well, we already said you can pretty much push it to the max, right? Up to the point of, but not beyond, threatening someone. You can't. That's the line. So the Second Amendment, we'll move on from that to one of my favorites, the Fourth Amendment, which is, and now I didn't hold you responsible for this yet for the midterm, but for the final, you certainly need to know that the Fourth Amendment is a civil liberty that protects essentially your privacy. Now, I want to be clear. The U.S. Constitution doesn't use the word privacy. It never uses the word privacy. It's not in there. It also doesn't use the term separation of church and state. But both of those notions are all over the Constitution, right? So maybe the founders didn't say there's a right to privacy, but they wrote it in there. And where do I come to that interpretation? This is very controversial, but during Roe versus Wade, the Supreme Court justice, which is the landmark case that legalized abortion in all 50 states, the justices said, and you can look up these words, this is amazing how sophisticated the wording of people at this level is. They said, in the emanations and penumbras of the Constitution, there is an implied right to privacy. If you have no idea what that means, a penumbra is essentially like the shadow of the outside of a dying star, if I understand it correctly. So an opaque shadow. What they're saying is this. Maybe it's not in the Constitution, but it's all, like, in those exact words, but it's all there for us to see. We know there's a right to privacy. So they just said it in a really fancy way. So go look it up. Emanations and penumbras is the way the Supreme Court put it in what I would say is one of the most important, whether you are, whichever side you're on of it, Roe versus Wade is one of the most important Supreme Court cases in U.S. history. I don't think anyone would dispute that, no matter which side you're on. So why do I say that? Well, because in that case, they said, even though there isn't the word privacy in the Constitution, of course there's an implied right to privacy throughout the Constitution. In the shadows, it's there, it's obvious, is what they're saying. So now, some people won't agree with that Supreme Court interpretation, but it did largely, whether you agree or disagree, establish what we now call the right to privacy. That word isn't in there, and so legally it's interesting how that became something that we all now say, like, I have the right to privacy. Technically, constitutionally, it's not in there, that word. So isn't this fascinating? I mean, at least I think it is. Hopefully you do too. It's fascinating how very slight word choices in the Constitution and law and Supreme Court and jurisprudence make all the difference. And so, just to, one more example to skip forward for a second, like the wording of the Eighth Amendment, you know, no cruel and unusual punishment. Cruel and unusual. It doesn't say cruel or unusual. It's for, so you can't do something that's unusual and it's also cruel. But you could do something that's cruel or something that's unusual. That one word, think about that. So the death penalty. Is the death penalty rare? Is the death penalty, we're going off of the question, right? Of, is the punishment, according to the Eighth Amendment, too much? Is the death penalty, no cruel or unusual punishment? That's the Eighth Amendment. Is the death penalty unusual? Is it rare? I shouldn't say rare. I should just say the constitutional words. Is it unusual? It's not unusual. Even if it is rare, it's not unusual. What do we mean? We're just objectively saying something. The death penalty's been around for thousands of years as far as human beings know. It's been used in almost every culture or society, almost, for thousands of years. It is definitely less used now than probably ever around the world, especially among our allies. Basically, none of Europe has it. Most of our allies don't have the death penalty anymore. But looking at it like a legal scholar, is it unusual? As the Constitution says, you can't have cruel and unusual punishment. Cannot have it. That would be a violation of your civil liberty. Is it? But it's not. It's not uncommon. It's not. So that, then you get to the cruel part, and then you can have another very deep debate over, is the death penalty cruel? Is it cruel? Or, I mean, other people are going to say, well, even if it is cruel, that's a murderer, they deserve it. I totally understand your emotion, but you, like, just looking at the issue, right? What is considered cruel punishment? For example, solitary confinement. If you put someone in one cell with no one else to talk to and potentially no sunlight for an extended period of time, and it's going to depend on the person and the psychology and a lot of other factors and the psychiatry of the situation. So many, but you put a human being in solitary confinement, at some point it damages them psychologically and psychiatrically. It wounds them, and it's a consideration then that's cruel, right? You don't want a punishment that is, according to the Constitution, you can't have one that is bending on cruel. But the unusual part, we went back to the death penalty. It's not unusual. However, how you enact the death penalty may be cruel or not. So, for example, what seems to be the consensus among people who are for the death penalty is that the fairest way that they've offered to do it is through lethal injection, where there's, if it works right, minimal pain, if any, and the person, they would say, is essentially falling asleep. Now, the other side is going to say, these are drugs that Europe has, like, outlawed, so we have to find or manufacture these drugs from various places, the drugs that will kill someone with a lethal injection. Sometimes there are multiple injections that do different things to the body. One paralyzes it, the next stops the vital organs, and so there's multiple. And there have been cases where in Oklahoma, and you don't have to look this up if it's too much, but I'll just briefly tell you that a death row inmate who was essentially poked with the needle dozens of times and they essentially tried to. He was he wasn't fighting it. He's like giving them the vein, and they just couldn't get it. And this leads to an interesting question to think about for the death penalty. Is a doctor who's taken the Hippocratic Oath, if you don't know what that is, look it up, an oath to protect their patient, the person, and try to help them at all, like essentially medically the best they can. If that's the case, is a doctor most likely going to be administering the lethal medication? No. Is a nurse? Maybe, maybe. Ethically, there would be some questions, right? If you're a nurse, though, you'd probably be even better equipped than a doctor, because nurses do more of that, as far as I know, of the actual, putting in an IV and so forth. These are all questions that linger around. Is that starting to become cruel then? Because now you have just a corrections officer that hasn't been trained, and he or she is now injecting this person, and they're maybe not even doing it right, and now the person's like trying to help them get a vein, and they're half dead, and it's just a disaster, right? So anyway, why do I bring this up? Because this is a great question for our country to ask itself: you know, is the death penalty cruel and unusual? And if it isn't, why not? And if it is, why? What should we change the law? Should we keep them the same? Every state has different laws. I'll just tell you, California voted in 2016 when the state went 2 million plus votes towards Hillary Clinton. Trump, although won the election, Californians voted on the death penalty. And there were two props, and they were kind of like equal and opposite props. One was saying that if you vote for this prop, you want to vote to end the death penalty in California and replace it with mandatory life in prison. In other words, you can't come out of prison no matter what. You die in prison, but we don't kill you. You just die of old age or whatever, right? That was one. So to replace the death penalty, get rid of it, but keep the person in jail for life no matter what. And then there was another prop, sort of equal and opposite one, which was that said, no, actually, let's speed up the death penalty. What do I mean speed it up? People that have been convicted of a crime, most likely, are going to claim that they're innocent. If there's, not always, but if there's a death penalty looming over them, and maybe they are, and they're going to appeal. They're going to go try to go to higher judges and courts and get somebody to stop it. Wouldn't you, right? So that's normal, but that does mean that it takes years, sometimes decades, for a person that's been sentenced to death to actually be put to death. That could be another question: is that cruel to have someone have the threat of death hanging over them while they hope for appeals for, say, 10 years? At some point this may happen to you. So these are all fascinating questions we can ask ourselves. But anyway, I didn't mean to jump into the Eighth Amendment. We're already here. So just to finish out the Eighth Amendment, cruel and unusual punishment. What is it? That's a great question. We know that the definition has changed and may continue to change. California, just to finish that point, with those two different propositions, one voting to speed up the death penalty because death row takes forever and there's lawyers and you get appeals, and the other was to just abolish death penalty. Well, the abolish the death penalty one lost, and the speed up the death penalty one won. So I know I'm putting it in plain terms, but so I don't lose the audience here. This is the point. The death penalty is the most severe penalty you can have, and Californians a couple years ago voted it in, and not only voted it in, but voted to speed up that appeals process. Now, you could argue that that's actually a just thing. In other words, if I'm innocent, I want my appeals to be sped up because I want to get out of jail because I didn't do anything, right? So that is a very important question and distinction. Californians voted to. So when Governor Newsom came in, he said that he was putting what's called a moratorium, which is a fancy way of saying he's pausing the death penalty. He's putting a moratorium on it. He basically said, under my watch, I'm not going to let anyone get the death penalty. But it's still on the books in California as law that was voted in by Californians. That is one of the, I would argue, with other scholars would probably generally agree, California is now one of the strictest death penalty laws in the country based on the vote of 2016, except for Governor Newsom putting the moratorium on. Now, the next governor doesn't have to put the moratorium on, and the law could then be enacted against, essentially again, if that makes sense. So the Eighth Amendment, we got some big stuff in that cruel and unusual part. And then there's the issue of, and just to read it from the actual language, it says excessive bail. So this is the Eighth Amendment still. This is the first part. Excessive bail shall not be imposed, nor cruel and unusual punishments inflicted. So we already talked about this briefly, but excessive bail or fines. Excessive bail, think about this. If you go to jail for something you didn't do, right? And say someone says, this person robbed a store, and that person's you. You didn't do it, but you have to go to trial to prove your innocence, okay? And let's say it's July 1st, you go to prison, and you're like, I know I didn't do it. I know I'm going to be found innocent. I have to go back to my job. I have my kids, I have my life. So the judge puts a bail amount, and he or she says, okay, if you put up $10,000, and this is what bail is, so you know. If you've never known this before, it's a good time to write it down. Bail is a way of the government, the judge, making sure you come back on the day of trial. You show up to court. It's a way of making sure you do that. Why? Well, because if I give $10,000 to the court to get out of jail until my trial, which is 3 months from now, you better bet I want my money back because I'm innocent and I didn't do it, right? Now, here's the concern. How do you get that $10,000 if you're innocent and poor? You're innocent and you don't have that much money. What do? And the answer is, it's troubling. So here's what you probably have to do something like this. So you get that $10,000. You don't have anyone in your family or friends that has that much money. So what you do is you call a bail bondsman, or whatever they're called. You see them sometimes, the bail bond. There'll be commercials once in a while, or a billboard, or maybe even a car that has it, on there, and it'll say, like, if you're ever in trouble, call this number and we'll bail you out. That's so nice of them, just to volunteer to pay for people. That's a business. They're not volunteering, they're doing it for money, right? So why? Because it's a smart business. Someone wants to get out of jail right now. They don't want to be there. They don't want to sit and wait 3 months until their trial, especially if they're innocent. But they don't have $10,000. And honestly, it's going to be way more than $10,000 for this crime that we're describing of a robbery. But let's just say. So you call you're in prison. You get one phone call. You call the bail bonds person and you say, come give me the 10 grand. And they say, okay, we charge, 8% fee. I don't care. Come pay. Okay, my math isn't that good, but I'm pretty sure 8% of 10,000 is 800. So you're talking about spending. So remember, you're innocent. So you pay them the $10,000, but there's a fee they charge. That's why they're a business. So they charge you $800. It's not their fault you're innocent. This is just a business. Here's the good news. You pay the court that $10,000 and then you owe them that 800, right? You pay the court and you go home. and you come back after trial, I mean, when trial is occurring, excuse me, and you prove yourself innocent, your lawyer that you get helps you prove it. We'll learn about that in civil rights in the next lecture. Your your lawyer helps prove that you're innocent, and the court's like, all right, we were wrong. Here's your $10,000 back. That's fair. That's awesome. Okay, so I didn't actually owe anyone. But wait a minute. The bail bonds people, I paid $800 to get that 10,000 so I could go out home for a while until trial starts and not sit in jail and look guilty and just who wants to be in jail? As far, I mean, that's probably a good way to look at it, right? So you pay the $10,000, but you pay the fee. Now they give you back the 10,000, so you give them back that money. But where's the other 800 come from? The other 800 comes from you as an innocent person. We're gonna have to just straight up pay $800 to have proved that you're innocent. Technically, you paid $800 to get out of jail and come back to your trial so that you could prove it. But what that means is you, hopefully, if you got bailed out, you didn't lose your job, you didn't, lose your kids, whatever, right? That is why this question about civil liberties is so important. What it says in the Constitution, excessive bail shall not be required. What counts as excessive? Civil liberty, like, okay, so how big is my civil liberty here? I would argue that it would depend on the person, right? So if, like, say, Bill Gates or someone really wealthy gets in trouble and their bail is $1 million and they're a billionaire, that's like you and I having a bail for $10 or something, right? Not even. So most scholars that are bipartisan that are looking at this are going to say the fairest way to do bail in a constitutionally consistent way that it's not excessive would be to look at how much someone can afford. How much do they make? If they make nothing, then that's a big, that's serious. You have to consider maybe even not having bail. And I know that might say, well, people won't come back for their trial. Look, if you don't come back for your trial, you're in so much more trouble. So the motivation for somebody who's done either is innocent, of course they're going to go back and prove they're innocent. The government's not going to let this rest until you prove it, right? So does that kind of give you a picture, hopefully, of, the aspect of what civil liberties can look like constitutionally? Okay, we'll sign off from there and we'll pick up in a second. See you soon, guys.